All rise. The High Court is now in session. Honorable Judge Nur Solehah is presiding. Please be seated.
Good morning, ladies and gentlemen. Calling the case of Public Prosecutor versus Mutusami, the accused has been convicted of robbery with the use of a weapon Section 392 and Section 397 under the Penal Code. Today, we will hear submissions on sentencing. Are both sides ready? Ready for the people, Ya Arif?
Ready for the people, Ya Arif.
Good morning, Ya Arif. Ladies and gentlemen, I am Amira Yasmin, who will be here as a lawyer for the appellant. Ya Arif, the appellant respectfully refers to the High Court case of Amir Hassan Ali Kusim against public prosecutor to support the mitigation of the appellant's sentence, considering the appellant's first offense and the age of appellant. The appellant humbly submits that the appellant is a first offender, and the appellant believes it is pertinent to note that although he has been arrested previously, those prior offences are dissimilar to the current offence for which he is convicted. The appellant was previously convicted for theft and resulted in only a fine. Thus, this prior incident is unrelated to the present robbery charge. It is crucial to distinguish between his past offences and the current matter to ensure a fair assessment of his situation. As illustrated in the case of Zaidun Sharif against public prosecutor, wherein the High Court held that a previous conviction is to be taken into consideration only if it is of a similar nature with the current charge. Furthermore, Ya Arif, the appellant is aware that imprisonment for a term which may extend to 14 years and whipping will be imposed pursuant to Section 392 and 397 of Penal Code. And should the High Court decide to sentence the appellant to 3 years of imprisonment. In this regard, the appellant humbly requests this Honorable Court to consider the appellant's age. As of the date of this hearing, the appellant is 21 years old, which is relatively young and should appropriately be in the rehabilitation center.
Good morning, Ya Arif, ladies and gentlemen. I am Nur Anisa Wafa, who will be here as the lawyer for the appellant. Ya Arif, the appellant mental health rendered him unfit to be sentenced to the maximum number of imprisonment. Article 7 of the International Covenant on Civil Political Rights (ICCPR) laid down that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Yang Arif, the appellant refers this Honorable Court to the Court of Appeal decision in Public Prosecutor against Morah Sheikh Mudi Shukudi, where the court had set out a list of circumstances that can amount to mitigating factors, which including the age and health of the accused. At this juncture, the appellant would like to bring the Honorable Court's attention to his mental health condition, namely that he suffers depression due to him being the sole provider for his family. His father, as at now, paralyzed and requires constant care, his unemployed mother, and 3 younger sisters who are still in school has rendered him in making the decision out of desperation after he failed to secure financial assistance to pay for his father's surgery. Moreover, Ya Arif, the duration of imprisonment itself would be traumatic to the appellant, as he has to face the constant fear of his family's well-being without him to provide. Lastly, the appellant believes that he is intrinsically unfit for the maximum year of imprisonment, and that this Honorable Court, as the pillars of justice and fairness, reduce the year of imprisonment to the appellant.
Yang Arif, throughout the years of his previous conviction, he has been employed as a clerk and maintained the employment, and then he shows his willingness to work honestly and it demonstrates responsibility by supporting his entire family. He has constantly been diligent to earn his own income without relying on handouts. Therefore, if he is being sentenced less than 14 years, he will be a beneficial member to the society. Furthermore, he pleaded guilty immediately upon being charged in the court, showing remorse and acceptance of responsibility of his action. He acknowledges his mistake and is certainly unlikely to make the same mistake again, knowing the consequences that could befall himself and his family. In light of above statement, the appellant submits that he has displayed nothing but good behavior and it can safely be said it will not be against public interest to reduce his sentence to 3 years imprisonment from the time of arrest.
At this juncture, Yang Arif, we would like to summarize the mitigating factors submitted in support of the instant application, namely to reduce the appellant's sentence, which the first one is the appellant is a first offender, the second is the appellant's mental health has been in constant decline owing to his responsibility as a sole provider, and the third one is the appellant has demonstrated a remorseful and responsible to his action. In light of the submission above, the appellant humbly submit that this is a fit and proper case for this honourable court to reduce the appellant's sentence to imprisonment of 3 years.
Good morning, Ya Arif. Ladies and gentlemen, I am Burhan Hazim Adam bin Abdullah, would be here as a lawyer for respondent. May it please the court, Ya Arif, I respectfully refer this court to section 397 of the Penal Code as the sentence that should be imposed on the accused, Mutusami, who stands convicted of robbery with a weapon under section 392 of the Penal Code. While my learned counsel has painted a sympathetic picture of the accused, I must draw this court's attention to several aggravating factors that demand a deterrent sentence. Firstly, Ya Arif, this was not a simple theft, but an armed robbery. The accused made a conscious decision to arm himself with a knife and threaten an innocent worker. This premeditation shows a calculated intent that cannot be ignored. Moreover, the victim suffered actual physical harm, requiring medical attention and stitches. The psychological impact of being treated at one's workplace cannot be understood. Ya Arif, I must also address the accused's antecedents. This is not his first brush with the law. He has a previous conviction for theft. The progression from theft to armed robbery shows an escalating patterns of criminal behavior. The previous fine imposed clearly failed to serve as a deterrent. Defense has emphasized the accused's difficult family circumstances. I must admit that financial hardship, however severe, cannot justify threatening violence against innocent members of society. Many in our community face similar or worse circumstances, but do not resort to armed robbery. There are legitimate channels for financial assistance that the accused could have pursued more vigorously. Ya Arif, there is also a pressing need to consider public interest. Convenience store robberies are becoming increasingly prevalent in our society. This establishment, often operating late hours with minimal staff, are particularly vulnerable. Store workers deserve the full protection of the law. Therefore, I believe that a lenient sentence in this case would send the wrong message to the others who might be contemplating similar acts. The defense has emphasized the accused's youth and role as a family provider. However, at 21 years of age, he is mature enough to understand the gravity of his actions. Being employed and having family responsibilities should have made him more, not less, conscious of the consequences of his action. Therefore, Yang Arif, while we acknowledge the mitigating factors presented by the defense, the prosecution submits that a deterrent sentence is necessary in this case. The sentence must reflect not only the seriousness of the offence, but also serve as a clear message that armed robbery, regardless of the perpetrator's circumstances, will be met with appropriate severity. Thank you.
The court now in recess. All rise. All rise. The High Court is now in session. Honorable Judge Nur Solehah is presiding.
Having heard submissions from both the learned prosecutor and defense counsel, I now proceed to deliver my judgment in this case. The accused, Mutusami, stands before this court having pleaded guilty to the offence of robbery with a weapon under Section 392 and Section 397 of the Penal Code. The facts reveal that on November 12, 2023, he robbed a convenience store at knife point, causing injury to the cashier and taking 1,200 ringgit, which was subsequently recovered. This court must balance several competing considerations. On one hand, we have the serious nature of the offence. Armed robbery is a grave crime that puts public safety at risk. The accused not only threatened violence but caused actual injury to the victim, who required stitches. The psychological impact on victims of such crimes cannot be understated. The prosecution has rightly emphasized that the accused has a previous conviction, albeit for a less serious offence, and that financial hardship cannot justify resulting to violent crime. However, I must also carefully consider the mitigating circumstances presented by the defense. The accused is 21 years old, employed, and the sole provider for his family, including a disabled father requiring urgent medical care. His immediate guilty plea demonstrates remorse and has saved judicial resources. The stolen money was recovered and the injury caused was not lasting. A significant factor in this case is that the crime appears to have been committed out of desperation rather than malice or greed. While this does not accuse the offence, it provides important context for sentencing. The purposes of sentencing include deterrence, rehabilitation, and public protection. In this case, I believe there is good prospect for rehabilitation given the accused's youth, employment history, and family responsibilities. Taking all factors into consideration, I sentence the accused to 3 years imprisonment. However, taking into account his circumstances and potential for rehabilitation, I will suspend 2 years of the sentence. This means the accused will serve 1 year in prison, with the remaining 2 years suspended for a period of 3 years. This means if he commits any offence during the 3-year period following his release, he will be required to serve the remaining 2 years in addition to any new sentence. I also order him to perform 200 hours of community service upon release and to attend financial management counseling. This sentence, I believe, appropriately balances the serious nature of the offence with the accused's personal circumstances and rehabilitation prospects. It sends a clear message that armed robbery will not be tolerated while providing an opportunity for the accused to reform and continue supporting his family. That is my judgment.